I'm now issuing a magistrate's order for emergency protection that identifies the complaining witness in this case as a protected individual. You cannot communicate with this person in any manner. Phone calls, text messages, any way. You're not to threaten, harass, use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where she lives or where she works. Do you understand? If I find that you violate this court order, I'm just going to put you in jail. Got to understand, I'm going to protect my public at all costs. I don't care who you are, what color, whatever. Do you understand? Now, I'm not waiving his appearance because the cases are super old. We got to figure out where we're going. So I'm going to give you guys one setting to figure out where we're going to go. Is discovery complete on both of these cases?
It appears that the RIP is missing on the terroristic threat and on the assault. It's complete.
So, okay, so I'm going to give you 30 days. You must be back at that time to figure out what we're going to do. You must either accept a plea bargain from the state or else I'm going to set your case for trial. You understand? Okay, so if you can please put offers on both of the cases, we'll see you back in 30 days. So we'll go from there.
Understood, Judge. Thank you.
In the assault, is she the same complaining witness in the assault?
Yes, Judge.
Okay.
Hey, I want the roll up also on the assault as well. Yes. Both.
On the AFM, you want it on?
On both.
On both?
Yeah, it's the same complaining witness.
Okay.
And Your Honor, the bond conditions would be no contact.
Yeah, no contact.
No weapons. On both.
The thing is,
Two different complainants, Your Honor. One is the father on the assault and the sister on the terroristic threat.
Alex. So I'm granting it in both, so you're not to have any contact with either person. The bond conditions aren't going to, doesn't really matter because this thing lasts for 61 days, right?
Yes.
So this case ends before the 61 days.
And that is correct. The sister for the terroristic threat and the father for the assault.
All right, Judge, next is page 8. Fair, come on up.
It's fair. You are charged with assault bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On January 3rd, 2025, the officer was dispatched to a disturbance at a residence in Harris County, Texas. Upon arrival, the officer met with the complainant, who knew the defendant as his sister-in-law. The complainant stated the defendant came to his residence shortly after a verbal dispute with his child's mother, and the defendant arrived and told the defendant told the complainant to come outside and meet with her boyfriend. When the complainant stepped outside, he was assaulted by the defendant by a closed fist to the back of the head. The complainant stated the defendant continued to strike him in the back of the head before he began stumbling down the stairs. The complainant was then assaulted by an unidentified black male while still being assaulted by the defendant and the defendant's sister. The defendant was gone on arrival but was contacted via a public service by the officer and was ordered to return to the location.
Did the other person get arrested as well?
It appears there is a connected case, Your Honor.
The sister was also arrested.
So we have 3 co-defendants or
No,
2 co-defendants?
Yeah, just the sister, Your Honor.
Do we know of alcohol or any kind of,
There's no allegations, Your Honor.
see that she's on probation as well. There's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm also ordering you not to be in possession of weapons, not to have contact with the complaining witness in this case, and not to be in contact with any of the co-defendants. Do you understand? Yes? Okay, if I find that you violate these conditions, I'm going to revoke your bond. I'm going to put you in jail. I'm going to protect my community at all costs. You understand, ma'am? Ms. Fair, I need you to fill out an application for me. I'll provide you a lawyer after that. Don't violate these conditions. Do you understand, ma'am? Okay, please. We'll have you sign a receipt. You'll get with Fleischer for your bond conditions, and then we'll have you fill out an application.
I spoke with the complainant and
Ma'am, hold on. Come back up.
he's no longer living, he still has the lease to the residence of the 1180 Grant Road, but he's not living there anymore because the co-defendant lives there. He's actually living at his sister's residence, so if we could get a restriction, like a
Sure, just provide it to Felicia so she knows, and then we'll put that in the order as well, that she's not to go to this location.
yeah, Judge.
Okay, okay, ma'am, please.
The financial affidavit?
Yes, ma'am. Yeah.
Judge, you signed a transfer order for Little Hayward and you're ready for activities, but you signed for both. Could you unsign for the receiving judge so I can send it to court?
Yeah.
You just transfer orders. Oh, and there's some duplicates in there as well.
Okay. Counsel, do you have an arraignment?
I was thinking this situation.
We have special prosecutors that are here on that.
Okay.
Let me call, see if they're coming. Hold on, give me a second.
Judge, I can send them an email to swing by.
It'll be faster this way. Hold on. Hey, are you coming up?
Cogdill, Christopher?
Yeah, I've got a lawyer here that needs you on a case. Yeah, that's fine. Just wanted to let you know. That's it. Okay. All right. Bye. You were Dedrick Addison?
No, Judge, they didn't come on. Page 6, bottom of 6.
Mr. Cogdill?
Yes, sir.
Sir, you're charged with terroristic threat of a family or household member. That allegation kicks it up to a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 1st, 2024, the officer is dispatched to a terroristic threat call in Harris County, Texas, and the complainant and the defendant have an on and off dating relationship. The defendant is also the father of the complainant's child. The complainant stated they got into a verbal argument and she recorded it. The officer listened to the recording and the defendant stated he was going to beat her mom up and kick the door open and kill everyone in the house. The defendant also stated he has nothing to live for.
Mr. Cogdill, I'm going to find that there's probable cause to go forward with your case. Do we know if she wants to have contact with him or not?
Let me see if a RIP has been. Your Honor, there's been no contact made as of now.
Until I know that this person wants to have contact with you, I'm ordering you not to have contact with this person and not to be in possession of weapons. Do you understand?
Yes, sir.
Just be good. It's not hard, you know. Would you like me to provide you a lawyer today?
Yes, sir.
Okay.
All right, Judge, next counsel is here on page 28.
Mr. Downey.
Schreiber?
Oh, hey. Wow, 2 times in 1 week, huh?
Back to back.
Go play the lottery. It's Schreiber?
Yes, sir. Judge Kyle Schreiber.
Come on up, Mr. Schreiber. Good morning, sir. Sir, you're charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 16th, 2025, the officers made contact with the complainant at a residence in Harris County, Texas, who stated the defendant came to the cul-de-sac on a dirt bike, began revving the engine, which got the complainant's attention, and the complainants began recording the incident on their cell phone. The officers reviewed a video from the cell phone showing the defendant sitting on a dirt bike, continuously revving the engines, and the complainants made contact with the defendant, and the verbal argument began. The defendant made the comment, "It's y'all asses. I know where you live. I got y'all." And the complainants feared for their lives, believing the defendant would return to cause them bodily injury. The defendant's residence is only 0.7 miles from the complainant's residence.
Judge, I think the facts are going to show this stems from a confrontation that the neighbors had with his children, and that there's more context to the alleged threat that explains that. However, my understanding is
So are they next door neighbors?
they
So-
live in the same general neighborhood, but there's already a pretrial bond condition of no contact.
Got it.
And I've explained to Mr. Schreiber that staying away from them is good.
Just really, that's all we're asking you to do. You know, you've got a great lawyer. Listen to him. He'll take care of you. I am going to find that there's probable cause to go forward with the case. Just don't have any weapons, don't have any contact, and all will be well. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Downey, and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you because you've taken off, I'm going to issue a warrant for your arrest. Just don't pick up any new cases, okay? We'll have you sign a receipt with Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. All right? Thanks, guys. Please. Can you file the no contact?
Yes, Judge.
Yeah. Just maybe we approach.
So apparently I spoke with William about this case, and he, on the paper plate, which you have not seen, took a picture of the QR code. And it does pull up as though,
So what do you guys think?
Honestly, Judge, I don't know enough about motor vehicle registration to know what this QR code means, but I do know that when I did the QR code, it did pull up something.
And it did say the created timestamp was December 7th, 2024.
Oh, we can show you both. You like to see?
So wait. The paper plate has a QR code?
It has a QR code
apparently,
on the corner, and when scanned, it gave the date of December 7th, 2024 as the creation.
but this is end February
5th, which is the expiration.
So the
on-
issue is, because
of knowledge.
did he have knowledge of its falsity?
Right.
Did he, or, did he, because it's a specific intent crime, right?
Right.
And after Googling what a paper plate does look like, it looks exactly like it's supposed to. It's a little wrinkled, but that doesn't really.
All right, so I'm going to find no probable cause then.
Hey, Judge.
All right, guys. All right.
Okay.
Yes.
Thanks, Marco.
Thank you.
They'll call them up to sign this bond.
Marcos, just tell me to be careful, just, hey. I know, when you go to these places,
I'll give them
yeah. Given a rating?
Yes, it's for Blake Jenkins.
Okay.
And Judge, I showed up and he is wanting me off the case. He wants a new attorney.
Jenkins, come up, please. Gibson, Sean? We'll do that next.
I think I've got Jackson. Yeah, Jackson.
Hey, no talking. Speaking of, why don't we get some out and start signing conditions, we can get them out.
We're waiting on bond conditions.
There's somebody in a few minutes.
All right, let's get them out.
Judge, this is Jenkins on page 14 and 15.
I'm signing conditions so we can get some people out of here, please. Okay, so why are we here on Mr. Jenkins? What happened?
Yes, he was on bond and there's a new offense, so we're here for an arraignment. And then,
So he's on bond for 2 cases. He's now picked up a 3rd case. Is this right?
that's correct, yes.
Mr. Jenkins, you now stand charged with the offense of reckless driving. You are facing up to 30 days in jail and/or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, Judge. On January 12, 2025, at 6:26 p.m., the officer observed the defendant's vehicle traveling at a high rate of speed on a feeder road without headlights on. The officer checked the speedometer and it read 80 miles per hour while the defendant's vehicle was traveling faster. This occurred in a 50-mile-per-hour zone. The officer observed the defendant's vehicle make an unsafe lane change, cutting off a motor vehicle and reaching a speed of 106 miles per hour with moderate to heavy traffic. The officer observed another unsafe lane change while attempting to catch up to the defendant's vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle.
Mr. Jenkins, I'm going to find that there's probable cause to go forward with the case. Does he have a valid Texas driver?
Yeah, eligible.
I'm now revoking your bond on the other 2 cases. You will go into custody with me because you picked up a 3rd case, sir. Goes with you.
Judge, he also is wanting me off the case. So I didn't know if we wanted to
I
address that.
wanted to have
I'm not going to talk to you about this case. You have a lawyer. You need to talk to the
Talk
lawyer.
about my two kids before that, sir.
I'm not going to talk to you about this. We'll put you in back if you want. I can give you a new lawyer today.
Okay, anybody.
I'll give you a lawyer, another. If you want to get off, and I'll provide you another lawyer. It's the 3rd case. Unacceptable.
Damiento,
So we'll take you off and we can appoint another lawyer on all 3.
Lyra? Yeah, James.
Right, Judge, ready?
No. Give me a second. So, 5,003 on the old cases, please. I need to get Mr. Darvish here real quick on Gibson.
It's Jackson.
Violations, page 13 and 14.
Gibson, come up.
Judge,
Your Honor.
Sean, tell me.
I have Mr. Jackson.
Oh, I'm sorry. I was looking at
JP has Gibson.
the case. Sorry about that.
Jack,
No worries.
come on up.
Mr. Jackson, you now stand charged with another case. You were charged with possession of marijuana. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 18th, 2025, the officer observed the defendant's vehicle traveling 78 miles per hour in a 60-mile-per-hour zone, have an expired registration, and failed to maintain financial responsibility on Interstate 45. The officer noticed a prominent odor of marijuana trailing the defendant's vehicle, and a traffic stop was initiated. The officer observed the defendant to be in the driver's seat with a black bag and a female to be in the front passenger seat. The defendant rolled down the passenger window, and the officer observed a cloud of smoke emitting from the vehicle with an odor of marijuana. The defendant was asked to step out of the vehicle with the black bag. The black bag was opened, and the officer observed a clear jar with a green leafy substance known to be marijuana based on training experience, along with a digital scale and individual baggies. The defendant was searched for weapons, and the officer found more packages of marijuana inside his private area. The weight of the marijuana was 1.82 ounces.
And Your Honor, if I could adjust probable cause.
Okay.
Your Honor, so while I don't dispute the reason for the stop here, I think there's a couple things that stand out. So there is a alleged smell of marijuana that comes from the vehicle, and then an alleged cloud of smoke that comes from the vehicle as the windows are open. So first off, the officer doesn't specify whether this is a cloud of course, burnt marijuana, which I would assume, or vaped marijuana, because those are two very different things with two very different distinct smells. Additionally, if the officer is pulling him out and looking for marijuana and he has this cloud, then he would be looking for burnt marijuana, right? So he would be looking for a roach. He would be looking for a blunt. What he does is he looks inside of a plastic bag. If we have embered marijuana or we have a lit blunt, it's certainly not going to be in a plastic bag without the smell of burning plastic. Additionally, the marijuana that is found in the bag is in a sealed glass jar container, something that would not emanate a smell because a glass jar is essentially smell-proof. In this instance, I think we have an officer who went too far with the search because we have Mr. Jackson here who did not admit to possessing marijuana, did not admit to this being marijuana. The statute, of course, requires that this has to be marijuana, and we know we have the issues, of course, with the hemp bill. But Your Honor, if you're not aware, you can go into any head shop, purchase flowered hemp, open it, and it smells, looks, everything about it is identical.
I understand,
to
and
marijuana.
that, yes, I agree with you for a beyond a reasonable doubt standard, but here, this is just mere probable cause, right? There's a good stop, goes to the car, smells marijuana, there's a plume of smoke that comes out. Not only that, Sean, he signed an affidavit that he wasn't going to drive. He's not supposed to be driving regardless.
And I get the driving aspect of it, but I don't see how a cloud of marijuana from burnt marijuana gets you inside of a plastic bag. At that point, it becomes a fishing expedition as opposed to looking for the actual contraband, which he suspects that would be in the vehicle.
I don't know. I mean, I think that there's certainly enough to go forward. Beyond a reasonable doubt, I don't know. But this is just a probable cause standard, which is the low stand, So
I understand.
I'm going to find that there's probable cause to go forward with your case, Mr. Jackson. I ordered you not to drive. He's a driver in this car?
Yes, Judge.
Okay. I'm now revoking your bond. Goes with you. Sorry, Sean, but he promised us he's not going to drive. He signed an affidavit. He knows. He knew.
And Your Honor, will a new bond be set? And if so, can we get that amount set?
So I'll leave the first bond as is. The first case, I'm going to do it at 5,001.
Okay. So first case, 5,001, and then the new case, of course,
I'll
would be
leave
bonded
the
out
first
as.
one or the second one as is, though.
Which P round, Judge? Which case number?
So the one that's on page
14 or 13?
14, that one gets revoked to 5,001. Yeah.
Okay. Okay. Thank you, Your Honor.
Okay. Thanks,
I believe
Sean.
That's all.
Do you don't have anything else with us today?
Nope. I'm in Fort Bend for the rest of the day.
All right, good luck, my friend.
Thank you, Your Honor. May I be excused? You too.
All right, bye.
Okay, counsel, do you have an arraignment?
Yes, I was gonna talk to them.
Mr. Pons, great to see you, man. Been too long. Who's next?
One, Addison. Okay, page
Just
one.
Aris Delci? Ma'am, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On January 16th, 2025, at approximately 10:25 p.m., the officer was traveling on East Sam Houston Tollway and observed the vehicle traveling at a high rate of speed, overtaking other motorists and changing lanes without signaling. The officer observed the vehicle get on Ship Channel Toll Bridge and pace the vehicle at 75 miles per hour in a 50 mile per hour zone. The vehicle further failed to drive in a single lane and a traffic stop was initiated. The officer made contact with the defendant, the driver of the vehicle, and observed the defendant to have slurred speech and odor of an alcoholic beverage. Standard field sobriety tests were conducted, ATGN 6 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The defendant was read the DIC and refused to provide a specimen, and a blood search warrant was signed and executed.
Ma'am, I'm going to find that there's enough probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming anything of this nature, I'm going to revoke your bond, put you in jail. Do you understand, ma'am?
There's no driver's license on file for the defendant.
Okay. Any priority to BIs?
No priors, Your Honor.
If you do not have a Texas driver license and liability insurance, you are not allowed to drive. Do you understand? You will be signing an affidavit with me today promising me you're not going to drive. I take it extremely serious. You just saw what happened. If you don't have a license and insurance, do not drive. Would you like to apply for a court-appointed lawyer, ma'am? Okay. What's going to happen now is I will have you swear to it that you're not going to drive without those 2 documents. I will have you sign a receipt with Victoria. We will have you get with Fleischer at some point for your bond conditions. In the meantime, we'll have you fill out an application, then I'll have you speak to a lawyer here momentarily. All right? Please. And then if you could give her an application. Do you mind, please?
12, Humphrey, come on up.
Yeah, this was just if you just raise your hand. If you're doing. Yes. These songs from the viewer not operate or without a down.
Good morning, Mr. Humphrey. So you're charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes,
You have the right to have an attorney present. If you're not afford one, one will be appointed to you.
Yes, Judge. The officer was conducting a follow-up investigation and spoke to the complainant. The complainant knew the defendant by name and sight as they were in a dating relationship for 2 years. The complainant stated they ended the relationship in 2023 but continued to be friends because they worked in the same building. The complainant stated she initiated contact with the defendant via cell phone. The defendant showed up at her location and talked. The defendant asked to hang out, but the complainant stated she was busy. The complainant left the location and got a call from the defendant, and the complainant told the defendant to leave her alone and hung up. The defendant called her 35 times and called her using a secondary number. The complainant blocked both numbers, and the complainant got approximately 100 calls from a no-caller ID number. The complainant answered, and the defendant told the complainant to unblock her, and the complainant hung up. The complainant arrived at her office and saw the defendant calling her and was knocking and attempted to open the door to her suite. The complainant was escorted to her vehicle, and the defendant contacted the complainant 39 times via his cell phone, 1 time via a secondary number, 6 times via email, and 100 plus times from a no-caller ID. The defendant spoke to the officer and admitted to calling the complainant 100 plus times from his primary phone number and his secondary number and sending emails because she blocked him.
Mr. Humphrey, I'm going to find that there's probable cause to go forward with your case. You're on bond for murder. You now picked up a harassment case. You're lucky to be out on bond. Now you picked up a new case. I mean, really. I'm ordering you as a condition of your bond not to have any contact with the complaining witness. I'm going to put a GPS monitor so I know you're not going anywhere near this person. I will protect my community at all costs. Do you understand, sir? You're not to consume alcohol, illegal drugs. I don't want you going within 1,000 feet of where she lives, where she works, no weapons. You know, life is really short. It would really suck to spend the next 50 years in a 6x9 box. There's so many fish in the sea. It's not worth it. You know what I mean? Really. Move on. Just, life's way too short. Really. The ability to hire a lawyer is what I'm putting. Or do you need a court-appointed lawyer? Okay. Just, I want my community safe, man. That's all I want. Please, you know, please. I have an application on file already. So I'm going to have you sign a release of Victoria. I'm going to have you meet with Fleischer for your bond conditions. I'll provide you a lawyer here momentarily. Just think before you act. Come on.
That's fine.
Judge, would you like me to mirror the felony court?
No. I just, no weapons, no drugs, no alcohol, and no contact with this person. No going within 1,000 feet of where she lives or works, please. Okay, ready?
All right, yes, Judge. Next is page 18. Martinez and House.
You have a translator for me?
Oh, he needs an interpreter.
Oh, sorry. Oh, my question. Page 19, Martinez, Christian.
You speak English, sir? Toma asiento.
Next judge is page 21, Montez.
Jesus Montes, you speak English, sir?
Yes, sir.
Come on up. So I've got Mr. Cedillo here on an arraignment with Gibson over there. We can do that next. You are Jesus Montes. Mr. Montes, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer met with the complainant who stated that her and the defendant are married, and while at the defendant's sister's home, they got into an altercation. The complainant stated that the defendant grabbed her by the neck and pulled her hair, causing pain. The officer observed redness to the complainant's neck area.
Mr. Montes, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Protective order that has been issued in this case, I would get to know it. If you violate the protective order, the state can and probably will file a violation of protective order against you. It's one of the worst cases you can pick up. You understand? Do you have the ability to hire a lawyer, sir? Okay. We'll provide you a lawyer today, but don't pick up any new cases. Don't endanger my public. You understand? I'm going to have you sign a receipt of Victoria. We'll have you take a seat in the jury box while we get your conditions. We'll have you sign it, and then we'll provide you a lawyer here momentarily.
Good. No financial affidavit, Judge?
No, there's one on file already.
Okay, we'll just judge Don.
Gibson.
Gibson. Okay. Gibson.
JP, you ready?
Did he file an attorney of record, Judge? I don't have one. Montez, go ahead and sign for yourself.
Mr. Cedillo,
I'm here, Judge.
I've got Mr. Gibson in front of me. So what are we doing? This is an old case, huh? Was this a 2B? Alex, is this a 2B?
It was, Judge.
Yes, Judge. It was a 2B.
Mr. Gibson, you were charged with criminal mischief. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Your lawyer is here with you on Zoom so that you know you're not alone.
Yes, Judge. On June 24th, 2020.
Hold on.
Yes, Judge. Yes, Judge. On June 24th, 2024, the officers were dispatched to a burglary at a warehouse in Harris County, Texas. The defendant and another unknown male were seen on a security camera approaching the warehouse in an SUV and gaining entry to the side of the building by pulling back 2 metal sheets that lead to 2 large holes on the wall. The complainant estimated the damages to be valued at approximately $800, and the complainant stated the defendant broke into the property to attempt to retrieve items that belonged to him. The complainant stated to have filed a civil lawsuit against the defendant for not paying rent.
Say it again?
The complainant filed a civil lawsuit against the defendant for not paying rent, and that the complainant was there to obtain property. Or the defendant.
Mr. Gibson, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Don't go back to this location. Do you understand? If you pick up a new case, if you go back to this location, I'm going to revoke your bond and put you in jail. No more PR bonds. Okay. Now you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Cedillo. JP, have you filed an attorney of record?
No, Judge, it's brand new. I'll get that done today, Your Honor.
Please.
Judge, I know you found PC, but just can you indulge me and can I just hear how my client was identified? I did not hear that.
Surveillance video.
Yes, Judge.
Okay.
That's what they say.
I mean, is there any description that it was him, or did anyone say that it looked like my client or anything like that? Did the officer look at the surveillance footage?
Yes, the DIM states explicitly that the defendant is seen on security camera coming onto the property.
Okay. We'll take a look at it.
If you get the video, it shows something different, come back. I'm always ready to entertain anything at a later time, you know?
Of course, Judge.
So,
thank you.
But until that time, don't pick up a new case. Don't go back. All right, so Vic, you want to give me a date?
Yes, Judge, how is March 25 through the 27th?
Let me see, Judge.
Judge, was that state's bond conditions?
Yeah.
Okay.
Judge, March 25 will work.
Yes.
Okay, jurors. Okay, so for now, I'll have you sign a reset. We'll have you take a seat while we get your bond conditions. We'll have you sign it, and then you'll be free to go. Okay? Signed. You are Jonathan Caldwell. Mr. Caldwell, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer observed the defendant's vehicle traveling 35 miles per hour in a 20 mile per hour zone on Pine Dust Lane. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle, and the defendant was not wearing a seatbelt. The officer further observed an odor of marijuana and asked where the marijuana was located. The defendant stated the marijuana was located in the back seat. The defendant gave consent to search the vehicle, and the officer found a clear plastic sandwich bag with a green leafy substance in the back seat and a glass container with a green leafy substance. The total weight was 0.921 ounces.
Okay, Mr. Caldwell, I'm going to find that there's probable cause to go forward with your case. Have you looked to see if he has a license?
It's not eligible, Your Honor.
Okay, you're not allowed to drive. If you don't have a license, do not drive. Do you understand? If you go get a license, if you get insurance, come back to me. I'll take this restriction off. That's your only condition. Don't get in trouble and don't drive. You understand? I'm going to have you sign an affidavit, which is a promise you're making to me. That's the only condition, Mr. Caldwell. Don't drive. Now, you have a lawyer. Remain in contact with him. I'm going to waive your appearance. You don't have to waste your time coming to court, but you must stay in contact with him. If he tells me he can't get in contact with you, I will revoke your bond. Just don't pick him a new case and be good. All right? Come on. Thanks, Mr. Cole. Have a great weekend. You too.
Judge, are there going to be state's bond conditions?
No, I'm not putting any conditions, just the no driving affidavit.
Counsel is approaching on page 2. Lauren, come on.
Mr. Pruitt,
Hello, Judge.
happy Friday, man.
The one you, on Barnaby was in jail for Lee County.
Oh, we reinstated, okay.
Here today because you wanted bond conditions.
Good morning, Mr. Barnes.
Good morning. Sir Daly, sir.
You made it out.
Yes, I did.
Just, we're not asking for much, man. Just be careful, behave, don't do anything you shouldn't do, you know? Is those cases are still open in Fort Bend or what?
The case is still open in Fort Bend. It's still pending. Your next court date is down there is
This on March, not all the cases are open.
One of them's still open. Paul Two's representing him. I talked to Paul yesterday. And it's set for sometime in March. I can't recall the exact
It's okay.
date.
Have we done PC on this yet or no?
We haven't done anything because he was in custody.
Right. Okay, so we're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. I just want to see if there's enough to go forward on your case. I don't know what happened. Okay, Alex, please.
Yes, Judge. On September 4th, 2024, the officer observed a hand-to-hand transaction between the driver of a parked vehicle and another individual. The defendant was a passenger in the vehicle, and the officer approached and smelled a strong odor of marijuana. The officer asked the defendant to step out of the vehicle and saw in plain view a scale in the driver's side door, and the officer detained the defendant and the driver. The officer found a bag of marijuana in the defendant's waistband pursuant to a pat-down, and the weight of the marijuana was 1.27 ounces.
Telling me he saw him do a hand-to-hand transaction or someone else?
The driver of the vehicle was a hand-to-hand transaction, and when he approached the vehicle, he asked the defendant and the driver who did the hand-to-hand transaction to exit. And furthermore, the officer smelled an odor of marijuana.
I know, but why would he search him?
What?
I get it on the driver because he sees the hand-to-hand contact with them, but he's just sitting there.
Your Honor, the only thing would be officer safety, just the pat down. That.
No. All right, Mr. Barnes, I'm going to find no probable cause. Just be careful. All right? Really. You hang with dogs, what happens? No. Well, you get flea. Well, you can get bit too, right? Please.
It's a bad dog.
Just don't hang out with the wrong people. All right?
Yes, sir.
Come on. We really have 4 open cases now with Miss Newton. What is your true name, ma'am?
I'm sorry.
Miss Newton, you now stand charged with 2 more cases. You're charged with another theft case. You're also charged with failure to identify oneself to a peace officer. You are facing up to 6 months in jail and or a $2,000 fine on both of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On January 17th, 2025, the officer was dispatched to JCPenney's regarding a theft or shoplifting. The officer made contact with the complainant, a loss prevention employee, who stated the defendant, Newton, and a co-defendant, Woods, entered the store, selected several items, put the items inside a personal bag, and exited the store, passing all points of sale without paying for the concealed items. The complainant stopped the defendants outside and escorted them back to the loss prevention office. While at the office, the defendant identified herself as Christiana Ray to the officer. An AFIS search came back to reveal the defendant's real name with an outstanding warrant out of Harris County, Texas. The total value for the items was $268.
She has a theft from December of 22, a theft from June of last year, and now 2 more cases. Was she on bond for either of these cases when she picked up the 2 new cases?
Let me see, Your Honor.
You are looking at Miss Newton here. Was she on bond for any of these cases, or were they all just in open status? It's 254, 8009.
Your Honor, it appears bond was made after the new cases. On the 19th, the new cases were picked up on the 17th.
In the full processing page, last name KOTUN, that's the original case, and there were multiple bonds posted on that one. A GOP and a surety, and then these other cases got put in.
On the 251, it appears she posted bond only one time on the 19th of this month. On the,
Yes, Judge, on the 243.
that's the one that was
the
in
GOP.
current status, right?
Yes, Judge.
Where are all those from?
So the theft, cause number 243 was a Dick's Sporting Good.
And so Dick's,
And then 251 theft was a Sephora. And then the most recent theft was a JCPenney.
Miss Newton, Miss Williams, I'm going to find that there's probable cause to go forward with the case. I'm now putting a monitor on your ankle so I know where you are at all times, and you are forbidden from going to JCPenney any JCPenney. You're forbidden from going to any Sephora. You're forbidden from going to any Dick's Sporting Goods. If you pick up a fifth case, I tell you now, your bond is going to skyrocket. Do you understand, ma'am? Would you like to apply for a court-appointed lawyer, ma'am? Morning, Mr. Price. Sir, you're charged with two cases. You're charged with assault of a family member. You're also charged with a garden variety assault. On both of those, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Ms. Judge, the complainant Terrell and the defendant were in a previous dated relationship. The defendant followed complainant Terrell into a bathroom of a bar and began to slap complainant Terrell multiple times in the face, struck complainant Terrell with a closed fist multiple times in the face, and grabbed complainant Terrell by the throat, but did not impede breath. The defendant would not allow the complainant to leave, and complainant Asher, friends with complainant Terrell, walked into the bathroom. The defendant struck complainant Asher in the face with a closed fist.
Who?
So complainant Terrell is the AFM and complainant Asher is the ABI.
Terrell, is that a...
That is a dating relationship.
Got it. Okay. Mr. Price, I'm going to find that there's probable cause to go forward on both of your cases, and I'm ordering you not to have contact with either person. Do you understand? On the family member case, I'm not seeing a protective order issued on Price. You see one?
I don't see one file again.
Okay. I'm entering now what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Terrell as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat of harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Pierwood Drive house. Do you understand? If you violate this court order, the state can and will file a violation protective order against you. It's one of the worst cases you can pick up. So you're also not to have contact with the complaining witness in the assault case and not to be in possession of weapons as well. We're going to file these conditions. You will need to sign it. Did you need a court-appointed lawyer today, Mr. Price? Okay. You can reach out to the MAC. I've got an application on file. I'm going to have you sign a receipt, Victoria. We'll have you take a seat in the jury box while we get all your bond conditions. You'll sign it, and then we'll provide your lawyer here momentarily, sir. Please.
Right this way.
Prices Moa for 2020, it looks like, I think, I'm not sure, but the prices of Moa for 2020,
Thank you for letting me
it's,
know.
I don't see anything.
it's like one page
Next
on,
is page
it's like the first page of the motion and then.
Oh, is that all there is?
So they filed
25 and
incorrectly.
26.
So I'm just gonna-
Randall, come on up.
The state will have to file.
Do you know how to file a MOA? I need a MOA filed on Price.
As well as NCIC, TS, and.
I'm not sure.
No.
Follow up.
I'm not sure I can ask you that.
Oh, yeah, I'll figure it out.
Yeah, please, on Price. It's the, it's 2322532, please.
As well as NCIC, TIC.
Did you hear that, Day?
Yes, sir.
Also the T and TCIC and NCIC, yeah.
Yes, sir.
All right. So can you do no contact on both of the cases? No contact with any witness, no weapons?
Yes, Judge.
Normal thing. You were Jamarcus Randolph. Mr. Randolph, you're charged with tampering with a government record. You're facing up to a year in jail and or a $4,000 fine on that one. You're also charged with possession of marijuana. On that one, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer observed the defendant's vehicle bearing a temporary buyer's tag with an expiration date of December 25th, 2024. The officer ran the expired buyer's tag through NCIC and observed the license plate to not be registered to any vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle, and the front seat passenger. The defendant admitted to having buying or printed the buyer's tag himself and putting it on the back of the motor vehicle. The defendant stated he printed the buyer's tag at UPS or something. The officer observed a strong odor of marijuana, and the defendant admitted to smoking earlier that day. A PC search of the defendant's person and vehicle were conducted. The officer located a small plastic bag containing a green leafy substance known to be marijuana based on training experience in the defendant's front right pocket, and a clear plastic bag containing marijuana in the center console of the vehicle. The weight was 0.3 ounces.
All right. Mr. Randolph, I'm going to find that there's probable cause to go forward on both of your cases. You look up to see if he has a...
It's not eligible, Your Honor.
You're not allowed to drive. I don't care what's going on in your life, Mr. Randolph. You will be signing an affidavit with me today promising me you're not going to drive. If I find that you do, it's not going to go well for you. Do you understand? If you want to drive, go get a license, get liability insurance. If you can show to me that you have both of those things, I'll take this restriction off. But I'm going to tell you now, if I find that you do, it's really not going to go well for you, sir. Did you need a lawyer today, sir? Okay. See, show file. I need you to fill out an application for me. I can provide you a lawyer today. Above all else, in the short life that we have, do not drive. This is an affidavit that you're going to be promising me you're not going to drive. Do you understand? All right, come on.
Then we're not done with the railings yet.
That's the only condition.
All right, Judge, next is page 26, Richard Randall. One's coming. The sign.
Did you say
Richard, page 26.
Good morning, sir. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. So this is the one that we were talking about the other day, right? Where it looks like initially a magistrate found no PC, right? But then we have a refile the next day. You go ahead and read PC. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer met with a complainant who stated that the defendant is her ex-husband, and the complainant advised that on August 25th, 2024, the defendant was at her residence regarding a visitation. As the two children went into the home, the complainant told the defendant to leave. The defendant then pushed his way into the home and pushed the complainant against a wall, causing pain. The officer observed surveillance footage showing the defendant push and strike the complainant in the upper chest area.
Oh, there's a strike.
Yes, Judge.
Okay. Mr. Reichert, I'm going to find that there's probable cause to go forward with your case. A protective order has been issued in this case. Get to know it. If you violate the protective order, the state can and probably will file a violation protective order against you. It's one of the worst cases you can pick up. You're not to have contact with this person and not to go where she lives or where she works. Do you understand? No. I can give you a lawyer.
Sir?
I can give you a lawyer if you'd like.
Yes, sir.
Talk to the lawyer, and the lawyer can come up and talk to me. I just don't want you to say anything. Believe it or not, I'm trying to help you because I've got a bunch of DAs here. Whatever you say, they're going to try to use it against you. All right? Do you need a lawyer?
Yes, sir.
All right. I'm going to have you sign a receipt of Victoria. We'll have you in the jury box. If you can file the conditions, no contact, no weapons, please.
Yes, Judge.
Have you signed the conditions, and then we'll provide your lawyer here momentarily. Okay? Please, sir.
You need this, Judge.
No, I have one on file. Thanks. For certain cases, they go in front of the magistrate, they'll already fill one out, so that's why I have it already.
Time for your Lisa. All right, Judge. Oh, next is page 27, Rocio.
Morning, Ms. Rocio.
How you doing?
Ma'am, you're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Hold on. We have a co-defendant here.
Moots. I knew, but I don't know if it's the one we already have on docket.
Do you have a cause number on the co-defendant?
Yes, Judge. 1 moment, it's loading. Okay, whenever you're ready. The cause number for Smoots is 2523672.
Okay, yes, Judge, he's on the jail docket.
So we have it?
Yes, I think he's on for the 27th.
So he's still in custody.
Yes, Judge. He has felony today. So we're getting him Monday.
All right, Mr. Rocio, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, Judge. On August 9th, 2024, the officer observed a silver Nissan with an expired registration and a traffic stop was initiated. The officer observed a strong odor of marijuana from the vehicle and observed marijuana in the back seat in plain view. A PC search was conducted and the driver, Mr. Smoots, was detained. The female passenger began to act very irate and yelled at the officer. The officers told her to back up and stop interfering multiple times, and she refused multiple commands. The officers attempted to place her into handcuffs, and she began to walk away and pull away from officers. The officer had to assist her to the ground, and she was identified with her driver's license.
Mr. Rocio, I'm going to find that there's probable cause to go forward with the case. The only condition I'm placing on you is not to have contact with the co-defendant in this case. You understand? Sorry? Do you have a lawyer? Do you want a lawyer? Okay, we can provide you one today, but talk to the lawyer. The lawyer can answer any questions that you have. I don't want to answer anything now because whatever you say, they can use it against you. Just the only thing I'm asking you to do is don't pick up any new cases. Don't have contact with the co-defendant in this case. Mr. Smoots, do you understand? All right, can you file those conditions for me, out, please? We'll have you sign a receipt, Victoria, and then we'll have you take your seat in the jury box. We'll get all the documents ready for you.
This way. Next judge is page 29. Where? Come on up. Come on. Oh, look.
Kiana, where?
I think outside. She's outside. She's coming.
You're in line.
All right, go ahead and have a seat.
It's arraignment Friday. Mhm. All Fridays are like this. You were Kiana Ware. Miss Ware, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 19th, 2025, the officer was dispatched to a two-motor vehicle accident on the 1900 block of Southwest Freeway. The officer observed the defendant's vehicle with damage to the front right side, and the officer made contact with the defendant, who was observed to have a strong odor of an alcoholic beverage, slurred speech, bloodshot, glossy eyes, and poor balance. The defendant stated she was coming from a friend's house, was driving home, and had drank 7 glasses of wine. The officer observed the defendant to be emotional and have changes in mood, and a witness, the other vehicle involved in the collision, observed the defendant in the driver's seat. Standard field sobriety tests were administered, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 4 out of 4. The defendant was read the DIC and refused to provide breath. A blood search warrant was signed and executed.
Are DWIs? Can you run?
No, Your Honor. And
Your
eligible
NCIC?
driver's license.
Have you run your NCIC?
Yes, Judge, and there's no prior DWIs.
All right, ma'am, I'm going to find that there's enough probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming, I'm going to revoke your bond, put you in jail. You understand, ma'am? Okay. Did you need a lawyer today, ma'am? Okay, we will provide one to you. I need you to fill out an application for me, and then I'll have you speak to someone. Don't use. That's all I'm asking you to do. Don't pick up any new cases. Don't be a danger to my public. Do you understand, ma'am? Okay, come on.
This way. Go ahead and sign for your Lisa. Judge, there was no driving restriction, correct?
No, she has a license, so she's okay. Just no alcohol, no tip.
All right, Judge, next is page 31. Williams, come on up. Mariah. Williams, Mariah. Page 31.
Williams, ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 13th, 2025, the officer was dispatched to a disturbance regarding a female in a motor vehicle on Westheimer Road. The officer observed the defendant stopped in the parking lot of a gas station and the officer observed the defendant exit the vehicle from the driver's side while holding her keys. The first and second complainant had previously seen the defendant driving between two gas pumps, hitting a trash can before stopping in the parking lot. The defendant proceeded to walk towards the officers, who observed the defendant swaying side to side, observed bloodshot glassy eyes, observed poor balance, and a strong odor of an alcoholic beverage. The officers then detained the defendant and performed standard field sobriety test, HGN 4 out of 6, walk and turn 7 out of 8, and one leg stand 3 out of 4. The defendant was read the DIC and agreed to provide a specimen of blood.
Okay, any priority to be nice?
No, Your Honor.
And I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. Do you understand, man? Did you say she has a valid Texas driver license?
I'm running it right now, Your Honor. It's eligible, Your Honor.
Okay, you can drive as long as you have a license and liability insurance. If you don't, do not drive. Do you understand? Do you need help with a lawyer today, man?